I'd be surprised if one of these other fellow judges are going to just flat out have this wholehearted disagreement with Judge Torres. So there's going to be people at the SEC that say we have to appeal this decision.
In today's video, Attorney John Deaton discussed the latest with the SEC Ripple XRP lawsuit, the recent summary judgments from Ripple and the SEC, and what's next for the procedural process, likelihood of a settlement soon.
Finally, on the appeal, just think about, I'm not convinced the SEC is going to appeal. They probably are, but I tweeted out today that it's the hottest debate going on over there, because you're going to have senior staff that say, look, you can just say XRP itself won, but that means nothing to all the other tokens. XRP is a unique story. XRP, was called a digital virtual currency by the Government Accountability Office in 2014. Your token wasn't. XRP traded for 7.5 years. Your token didn't. XRP this, XRP that. And you distinguish it and say, well, that's just XRP, facts and circumstances, facts and circumstances. How many times have you heard Gary Gensler say that in Congress? And just distinguish it. And you don't run the risk of a appellate court in the Second Circuit affirming this judge. So there's going to be some that say don't appeal and just go after all the other tokens, right? And then you're going to have some that say, listen, this decision is going to impact our case against Coinbase, which is in the same district, the Southern District of New York. And yes, it's true that the judge in the Coinbase case can completely disagree with Judge Torres, but we've already read the transcript, and she's saying things similar to what Judge Torres and Judge Netburn said. So remember that Judge Torres cited a fellow Southern District New York judge, Judge Castell, who had the Telegram case, in her decision. And so I'd be surprised if one of these other fellow judges are going to just flat out have this wholehearted disagreement with Judge Torres. So there's going to be people at the SEC that say we have to appeal this decision because of its impact on the Coinbase litigation and other litigation. I don't know which way they're going to go. If I were there, I would be in the camp of don't appeal it. If I worked at the SEC, and just go with your fact and circumstance and try to distinguish XRP on the facts. But there are others who disagree because of the impact it has on the regulation by enforcement. But know this, if the Second Circuit agrees with Judge Torres, then regulation by enforcement on crypto is dead, because the entire Second Circuit would be governed by that decision. And I can assure you that even judges in other circuits, like the guy in Library in the First Circuit, or in Seattle in the Ninth Circuit, that Second Circuit decision would have not binding precedent, but it would be massively persuasive. So that's where we're at with the appeal and whether or not it's going to be appealed. Let's talk about this decision, right? The Judge Torres decision itself briefly. And before I get into all of the noise that's out there, and I am going to address what Charlie had tweeted out there. I know a lot of people are wanting me to. I am going to address that. But first, I want to remind people of what we said, what me and my 75,000 friends said about this ruling before it happened. Now, I'm not playing that to rub in that I'm owed a steak dinner or anything like that. I'm pointing out that this decision that some securities lawyers are telling Charlie behind the scenes, off the record, in the shadows, were saying that it's crazy, right? That her decision was like unforeseeable. Well, then how come the guy that's not the career securities lawyer could see it coming pretty easily, right? Because if you get past all the noise and all the nonsense and all the bullshit, and you just look at applying this Howey test, a strict application of the Howey test to the facts of the case, To me, it was clear. That's why I said, hey, that doesn't mean that Ripple gets a clear victory here. But XRP itself and secondary sales, it's not going to be held to be a security. There's not a case in 76 effing years that the SEC can cite to say that when a person, a buyer, has absolutely no knowledge, no business dealings, no communications, nothing between that buyer and that seller, there's not a case in history that says that it's a security. So maybe it took a non-securities lawyer like me who was just looking at it very simplistically, right? Sometimes fresh eyes are the best eyes to say, listen, I don't see this, right? You can't cite a case in the whole damn history of securities laws, but this is going to be the one that the judge hangs her hat on with no precedent. Bullshit, right? And so that's why I said what I said. And so remember too about this judge that now seems to be under a siege. I defended the judge against some of my own people that were following me when they were like, oh, it's taken so long. This means that she is paid for and bought by the SEC. This means that, hey, Obama picked her. She's a lifelong Democrat, John. Therefore, she's never going to go against the administration's narrative, the administration's political agenda going against crypto. She's a lifelong Democrat. And I said, look, we looked at the research of this judge. She's always applied the law, without passion, without favor, strictly applied it. I see no reason that that's going to change, and it didn't change. And so, she was coming under attack before the decision, and now she follows the law and she says it, and I got a comment about, well, some people wrote an article that said that she threw out an indictment because of the racial implications of the grand jury. And look at that. You know what kills me about people sometimes? It kills me that they let their politics get in the way of their common sense, right? When a judge applies the First Amendment and allows free speech, people cheer that. When a judge applies the Second Amendment and says you have a right to bear arms, people cheer that. But if she throws out something because it violates the Fifth Amendment, or it violates due process clause, or it violates the Sixth Amendment right to an attorney, even if it is a scumbag, okay? Oh, she's out of control. He's out of control. I got news for everybody. The Constitution didn't get suspended because of COVID. So that case that they're citing her about, all right, COVID, Constitution didn't get suspended. And she just simply applied the law. And she said, it's out. And the prosecutors admitted to her that because of COVID, this is what they had to do. And then they redid it and everything's back to normal. So just be aware that politics sometimes gets in the way of people's judgment. Okay. And so her decision makes perfect sense. If it didn't, I wouldn't have been able to predict it like I did. Okay, I'm not patting myself on the back. I'm pointing out that her decision can't be that crazy, can't be that bizarre if a guy on national TV predicted it exactly the way it went down. Okay. Now, remember when I was talking about they didn't have a case in history, go back to Howey. There was a land contract that the investors sold for the orange groves. There was a service contract that the investors signed for to hire Howey to do all the work. You go to the Telegram case, there was an initial purchaser's contract of the token distribution, which was held to be a security. When you look at what Judge Torres said, she said that the contracts, the written agreements between Ripple and institutions, those were securities. Those met the Howey test. You see the business dealings between the hedge funds or the banks or the sophisticated investors in Ripple, just like there's this business relationship with Howey and the guy buying the orange grove and signing a land and purchase contract and hiring Howey service to plant the trees and sell the oranges and all the things that they did. That's what was required. And so when you apply that same logic to digital assets, it's why you get the decision that you get. Now, people want me to attack Charlie because of his position stuff. I'm not going to do that, but I'm going to, because Charlie said that he was talking to security lawyers, right? This is in his article where he says that he's spoken to SEC folks who brought the case. And he said he was talking to these securities lawyers, and not a security lawyer that he talked to believed that the judge would be affirmed on appeal. And so my challenge isn't to Charlie, it's to those lawyers. How about you come out of the shadows? Come not off the record, but on the record. How about you do that? How about you come on to crypto law, right? Quit hiding behind a shield of off the record and come talk. I'll meet you anywhere, any place, anytime, as long as it's live TV where it can't be edited. And we'll have the debate and we'll have the discussion. You want to call Judge Torres' decision crazy, bizarre? Let's talk about it. We know you won't, right? Because I got news for the world out there. When you get picked to be the SEC chairman, when you get picked to be the director of corporation and finance, it's not because you're the most experienced securities lawyer in the world. It's because you got political connections, right? When Trump picked Clayton, it was because of Clayton's connections, period. He was Mr. Wall Street. Rolling Stone magazine called Clayton the most conflicted SEC chair in American history. Gary Gensler's not a lawyer. How come he's the chair? Is it because he knows securities law so well? He wouldn't know a security if it bit him in his butt. And we know that. How many times does Gary Gensler get up there and talk about, oh, it's speculation and it has no intrinsic value? Read Howey. Howey tells you that it doesn't have to have intrinsic value. Howey tells you that speculation alone is not enough. Okay, but Gary Gensler was the chief financial officer of Hillary Clinton's campaign. He is heavily connected to the Democratic Party. The Democratic Party won the election. He becomes the chair. Got nothing to do with experience, got nothing to do with knowledge of the law. In fact, why did Hinman become director of chair? He got picked by Clayton. He's on video saying, I got the job because Jay Clayton called me. My good friend Jay called me and said, will you be director of corporation finance? Let me show you how much these so-called experienced securities lawyers know. Let's go to the Hinman deposition that was taken in this case. Okay, look at this question. Let me make sure I understand your testimony. This is a Ripple lawyer talking. Your understanding as you sit here today is that it's not necessary to satisfy all of the elements set out in the Howey test. Is that correct? In order to find a contract scheme or transaction, is an investment contract under the securities laws? That's the question. This is the answer. Bill Hinman says, my personal view is that you don't have to satisfy every single prong. And there are examples of that. Okay, so there is the director of corporation and finance. If he was correct that you didn't have to satisfy all of the Howey factors, then why did Judge Torres say in footnote 13, I'm not even going to get to the other two factors because the third factor is not satisfied. So people out there whispering in people's ears, off the record, living in the shadows. Come on, right? Sunlight is the greatest disinfectant, my friend, and I will provide you with a lot of sunlight. But no, I'm bringing the law and I'm bringing facts to the table.